Item number 32, my technical call. 32.
Yes.
I need 2 weeks time to file a reply.
Yes, we never Garnet Council for the petitioner. Praise for and is granted
2 weeks time.
2 weeks time
Right.
to file rejoin the record.
Right.
Please take on.
May I please refer?
Yes.
I beg to mention item number 5, Your Lordship. In this case, Your Lordship, a preliminary inquiry was put to challenge. Your Lordship. Now, Your Lordship, there was no stay order. In the meanwhile, the man retired, Your Lordship, and he is now settling somewhere else, Your Lordship. So I have instruction not to press to withdraw, Your Lordship, with liberty.
Mr. Court, as court support, Garnet Council for the petitioner submits that he may be permitted to withdraw this petition with a liberty file of this petition.
If necessary.
If so advised.
Deeply obliged.
Prior stands allowed. Accordingly, this petition stands closed on withdrawal with the liberty aspect.
Obliged.
May I please? Item 33, Your Lordship. I need some time to reply your.
Same order, but here NN 55.
Wait, little Lordship, item number 6 to 10. This matter, Sir R. Mozumdar will be appeared.
Hmm.
Out of session. This matter come up day after.
No. 2007.
Lordship, day after
We'll see.
tomorrow.
Wait.
Day after tomorrow, Lordship.
Wait.
Yes.
No, we'll not adjourn on the ground of lawyer. This 2007.
Only day after tomorrow, Lordship.
No. We do it tomorrow. There may be some other. Wait. We'll see. 30 and
31. Need to find out. But
you are for
I put a petition.
I Kolita. You are Mr.
Arbor.
Arbora. 30. For the petitioner, we rejoin the.
May this, with the consent of the other side, I beg to mention item number 24 of the date. May kindly adjourn the matter for today, as my senior is out.
Wait. 2018.
Lordship, I don't even have to pay.
We'll dismiss that.
My
If
senior.
that is your submission, a young counsel, you don't have the brief, don't come to show your case.
No, Lordship, I
No.
with it.
Rejected. Yes.
May I please, Your Lordship? Target detected on the good court matter.
Where is the order? Early order.
On the 27.
Huh?
Yes, 27.
Base?
27, man. On 1st of December. I'm open.
Have your satisfied?
Yes, sir.
Give a date.
February 1st, na? 21st of February.
I'm
What is the formula case? There is not.
Then is happy.
right.
Is the recall for his not received? Please, this matter.
Same date, 21.
21 to 2024 of interim order consultation.
Final.
44 minutes I have received instruction. Charge has been submitted.
Okay.
WD message has been.
Non appears to the another call. The data started treatment topic that submits that after completion of investigation, the investigation officer has already filed charge sheet being
494
494
oblique 23
oblique 23
dated 29/12/20.
in view of the apothec, the contempt bail petition that goes. It is needless to say that petitioner shall be at liberty to approach the competent court. Regular.
Nice to see you.
In the event such application fact can be considered learned by the courts below as part.
Yes, sir. Nice to see your lordship in good health.
No, yes, I'm in a now fit.
I know, yes.
May I kindly
Who here?
please, your lord? I'm appearing on behalf of respondent.
Let the file come. Yes.
Appearing on behalf of respondent, the petitioner has filed an IA for the amendment of main prayer of the
Where is that file?
we have not received the service copy of the same.
Yes.
We have filed IA for allowance to amend the IA number 315.
Have you served copy to the other side?
Yes.
Hmm?
No. Full sir.
No.
2 days. Sir.
What is this? This is a 2000. Let us see what is your merit of this. Then we'll think about amendment. 2015 is pending. Now you want to amend pleading. IAP. The present application is filed amendment of the connected writ petition in WPC number 1070/2000. Learned Counsel appearing for the respondent submits that no copy of such application is not upon them. This writ petition is pending since 2015 and the same relates to selection and appointment of counsel. Consider it as it may the petitioner to furnish copies of the IA to the learned counsels for the respondent during the course of that. Please dismiss that. After that.
Figure out. Matter it is to my lord termination of service.
Hmm.
If it is of proposed reply, petition was directed to submit a proposed reply. Allegation was that in the declaration form there was an omission on my part in not disclosing that whether there is any case pending against.
Hmm.
At that point of time, my lord, when I submitted my reply,
Hmm.
I specifically indicated that
Hmm.
there was no any case pending against me and no any common was even skipped by court.
Hmm.
I was never apprehended by police. On that faith, my lord, on good faith, possibly, my lord, there was some omission. That one, my lord, they on the
Who is
basis of-
representing Union of India?
Pardon, my lord.
Yes.
And on consideration of the reply, they have issued the termination. No department, nothing else. And I submitted my appeal immediately. Appeal was also rejected, confirming the termination. Now, my lord, they didn't file any affidavit.
At what stage you were terminated?
When I was, working, as a constable and posted in Srinagar,
Hmm.
issued the proposed notice. And ultimately, I was directed to submit the proposed reply. I submitted proposed reply. Thereafter, they issued the termination.
They have filed an affidavit.
I think, my lord, they didn't file.
They have filed an affidavit.
Copy was
Not only that, they have raised the maintainability, question of maintainability of this petition on the basis of the jurisdiction of this court.
I'm sorry, my lord, copy is not with me.
You better be sorry. You
Possibly, my
better be
lord,
sorry. Both of you.
possibly, my lord, the advocate who engaged me,
No, forget about it. You are not a designated senior. Engaged, forget about it.
I'm not a senior singer, but I was asked to appear in.
Don't say others. You are holding a brief. Don't blame others. We are in a repetition of 2015.
Copy is not with me. Now it is up to your lordship, if your lordship like to, my lord, to repeat it, put this for the book.
No, this is not a. We cannot do things on our likings or not like. We expect responsible behavior for senior members.
Because I am expressing my lord, honest and sincere, my lord, difficult. That copy is not with me.
Though an affidavit has been filed by the Union of India raising Union of India way back on 17/11/2015, raising amongst other a question of maintainability of this writ petition on the point of jurisdiction. However, till date, no reply has been filed by the petition. Mr. Purakasto, learned counsel for the petition, submits that he is not even aware of such filing of affidavit. Though the notice in original reflects that copy was received by Mr. A.K. Purakasto on 17/11. Be that as it may, considering the right of the petition, an adjournment is granted to file a reply affidavit. Reply affidavit. List this matter on after 10 days, after 2 weeks. February 23rd, 2024, by the said date, the petitioner could file affidavit, rejoinder, if so. The matter pertains the Union of India shall also be ready with the records pertaining to the decision of termination of the petitioner.
Sorry.
Hmm?
Copy.
Yeah. Because you say that he is aware.
Yes.
On what basis you say he is aware? There may be case pending. We know that case is still pending. He is not even attending the trial. So how will he know? Yes. Yes, tell us. What is it?
The contempt is regarding compliance of the order dated 6/9/2017.
Hmm.
The order starts at page 9
Page
9 of the contempt petition. And the operative part at 11, the directive.
okay. How it is contempt?
Lordship, there was a direction to consider the case of the petitioner for appointment in terms of the rules of 1999 within a period of 4 months. Lordship, after the contempt petition, we have completed. Lordship, there was during the pendency, an affidavit first was filed by the respondent number 1 herein. Lordship, the principal secretary government of Assam. They have the next the page 7,
Page 7,
Lordship, of the affidavit in opposition,
filed by
respondent number 1, filed on 21
respondent number 1.
One.
Sanction. Okay.
speaking order.
Hmm.
Speaking order says that the order portion, in
Hmm.
view of the above, the Deputy Commissioner Kokrajar being an appointed authority, take up the matter in accordance with the existing APS PA rule 1999 in light of the Judicial Department view and repealing the same and consultation with the person in the department to take a decision on the matter as deemed fit. Hereafter, Lordship, we have submitted a reply to that, which we have annexed the advertisement and my application form to the various courts.
Now,
Hereafter, Lordship, a letter was Lordship, in my affidavit in reply, Lordship, filed on 5/4/2009. Here, Lordship, page 4. There was a letter by the Undersecretary to the Deputy Commissioner regarding the name and address of the next
where? Advertisement.
after the advertisement.
Yes. Advertisement by Commissioner Transport Assam.
Sure.
Yes. Then
Hereafter, Lordship,
you applied.
yes, Lordship, I have applied.
Huh.
Also, there is a postal slip and another application.
Hmm.
At page 10. Hereafter, page 11, there is a letter regarding the employment of the families of martyrs. The name and address of the next one.
Hmm.
At page 13, the name reflected of it. At serial number 16.
Page 13.
Yes, sir.
Okay.
The serial number 16,
Hmm.
the name of my father. Hereafter, one of the affidavits was filed by the one number 3.
Hmm.
21/12. Here they have submitted all the communication. Page 6 onward.
Huh?
Page 6, the affidavit
Hiren Chandra Phukar. Whose affidavit?
respond number Niranjan Borpa. Here they have also the order, previous order 410.
See, ratio is laid down in the case of Narayan Bora. Page 68, Annexure 1 of the affidavit of Divyajyoti Datta. Okay. This is a ratio laid down. That what should be, how appointment should be followed. Rule 3 and 4. So there cannot be any direction as such to issue appointment. You will have to participate in the selection.
I have part
There must be a quota.
whether they have considered or direct. I have been making application.
You have not been appointed. You participated in the selection, meaning thereby you did not come in the zone of consideration. Until and unless you say that no, I have been wrongly deprived, your case is rejected because you are not selected.
Here they
No necessary to intimate you.
they are making appointment, Lord, I select all
Making appointments on what basis?
under the rules of
So under the rules, they will have to make appointment in terms of rule 3 and 4.
the APS period.
Under rule 3 and 4, rule 3 and 4 prescribes there must be a quota earmark. Isn't that it, Mr. Nath?
They have to, in a general.
Because they will have to
process, they have
participate.
to participate. If they are the equal with
Uh-huh.
some other persons, then this category of person will get
Preference.
preference.
So your non-selection itself shows that you did not perform well. So that amounts to that you have participated in 3-4 selection. You are not selected until and unless you challenge those selections, saying that no, I was equal with this person. I got this much of mark, but my case is deprived, ignoring my status. So within 4 months, there may not be any advertisement.
That petitioner has not, and but in fact, there is no.
Who will close this contempt matter?
Take the
What is that?
accepted by the petitioner. Starts at page 74.
It's 74.
Here I have annexed all my application form.
No, there is no
Advertising.
quarrel on that. You have
Whether
applied.
it is considered or not, because I have been making applications.
Do you say that they have not yet declared the result of the selection process pursuant to this advantage? Do you propose to say that if this selection has culminated in selection of some person and not you, that itself amounts to rejection or discarding your candidature? Now, next question will come whether you got the benchmark position in a selection process or you were put into an equal status of a selected candidate, same marks or same thing. However, despite that, being a special category candidate statutorily, you have not been, your case is not considered. If that be so, then two options, even then we may get it to be a contempt. Or you need to challenge that. In the writ petition itself, you may say that this is absolute contempt because there is an order in my favor. That preference is not given. There is no mandate under the rule to appoint you. The mandate is to have a preference if you are otherwise equal with others. Understand? So, no,
That they
the question is this, even in a writ proceeding, wrong cannot be ground of treating, equality cannot be on the basis of some wrong determination. Forget about contempt. Contempt is something more. Suppose they have done without preference because they belong to some person, selection is made. That will not give a right, or this court cannot issue a writ of mandamus on the basis of a decision taken, wrong decision taken by the respondent. That can have a different ramification, that can have a different challenge. Anything you want to add?
approach the
MS A Talukdar, Learned Counsel for the petitioner, seeks further 2 weeks time at this court. Prayer is allowed. Please take note. Mr. D. Nath and Mr. M. Bhagavati is present, representing the rest.
response.
Yes, why adjournment?
Sorry, out for 2 days. On Wednesday,
What is the issue, tell us?
is similar to the selection process, my lord.
Hmm.
Regarding selection process of Constable City, my lord.
Hmm.
Selection process of Constable City in Central Armed Police Force.
Hmm.
Here, my lord, case was that, my lord, suppose petitioner opted, my lord, one of, there are 6 posts, A, B, C, and F.
Hmm.
Suppose I opted one post, my lord, A, suppose A.
Hmm.
Their notification was there. I can be accommodated in other posts, consider maybe on other case also. There was the initial, my lord, notice is there, my lord, but that has not been done. Same issue, my lord, in earlier session, my lord, cited by this honorable court, my lord,
Hmm.
in Purupiri court case. That was challenged before the honorable Supreme Court, my lord. Supreme Court, my lord, pronounced judgment in favor of the, my lord, state. Now our, my lord, case is there, my lord.
Hmm.
There are other vacancies also. Altogether 64,000 vacancies are there, my lord, out of which, my lord, about 7,000 has been filled up. There are remaining 4,000-5,000 vacancies there. And the Honorable Patna High Court, my lord, once it, my lord, direct the, my lord, SSC, my lord, to fill up those posts. If they fill up those posts, my lord, then there are a number of petitioners before your lordship. They have, my lord, obtained marks in Thai criteria. Same mark obtained, my lord, but other persons selected on the basis of they put both marks in part 1, part A. So there are number of parts who are in Thai criteria. They will pay it, my lord. So Patna High Court order in the same special process.
We'll go to Patna later on. Let us be Guwahati for the time being. To more particularly to your fact, what was the advertisement? What was the criteria of the selection? To reach Patna, we'll have to pass many stations. Okay? Delhi is far away from Patna. Huh?
Whereas this it should be post.
When did you file this petition?
14 to 17.
Was there any interim order in your case?
They will maybe different in
Writ petition is in this way maintainable. Everybody's case is different.
Okay, my lord, either 12 marks or more marks, then the my lord, last
Somebody is having problem of date of birth. You have got lower mark then
have obtained higher mark,
Hmm.
then last either higher mark or equal mark. Now the regarding higher marks, they are saying, my lord, I have obtained my lord, A.
Hmm.
In A category, I got the below mark. But if I post my like, considered all course, then I will get my lord in another course.
So suppose in case of B, your mark is higher than the last candidate. In A, which
got-
you have given first preference.
Yes.
In where you have given first preference.
or single grip, single grip.
Now at this stage, after 10 years, what kind of relief can we grant you? Huh? Other cases were decided in the year 2017, isn't
Well,
it?
and they have relied on that case. On paragraph 10 of their writ petition.
Hmm.
Paragraph 10, my lord, they have relied
When
on
they have become wise after passing of the earlier judgment.
yes.
When they approach
And
this
that
court.
judgment, we immediately approach.
Hmm?
No, after the passing of the judgment, because the judgment was, this is recruitment of 2015, and it is published on 2 to 17. Judgment. In this Lord, recruitment of 2 to 7, and we approach 40. The provisional case, my lord, that was judgment of my lord, 2016. That was regarding 2012. Recruitment 2012. My lord, in paragraph 10, my lord, they have stated that they are relying on the judgment of the probate court. And that judgment, my lord, went to the apex court. And the issue which my lord learned petitioner is raising has been dealt by the apex court.
Which paragraph?
My lord, paragraph,
The judgment is there. Tell us the paragraph.
Supreme Court judgment, my lord.
Yes.
My lord, paragraph 33. The question that is, my lord, very
Give that. Give that. That is reported.
yes, reported.
Where is the answer?
Paragraph 34 onwards, my lord. So 45.
What remains in this list?
That
Then
regarding remaining vacancy,
what remaining vacancies? Kindly come to paragraph 40 of the Supreme Court judgment. Mr. And he could not show me the paragraph. You are with the judgment.
paragraph 45,
Take your seat. Take your seat.
No.
We'll do ourselves. Take your seat. Read paragraph 45. Then what remains? Why you need Mojumdar?
regarding preference, we have no question.
Then Mr. there. That is your case, preference, because you gave preference in A. You got lower marks in A. However, your second preference or B or C, you got higher marks than the person selected in B. But advertisement, same kind of advertisement, where clause 16 says that if this is the condition. So Supreme Court says how High Court can dilute the clause of advertisement. Method here.
The respondent of the method themselves were considered as candidate by the only one excellent candidate. Page 86.
So we'll have to say, since ignore this Supreme Court judgment.
That
Do
is
you
why
prop-
that
do
is
you-
well, no, that is why we preferred at that time.
So today this is nothing survived. Do you want a judgment to be dictated, or you want that in view of the order passed by the Honorable Apex Court, this dispute has been negated, accordingly this petition stands closed.
Regarding in WPC 325 by 2030.
Order dated.
Order dated by 7/12/2020.
So we could not even reach Kamakhya. Forget about Bihar. Isn't it? You should have said about the Kamakhya station. You are taking out to business. And you would have also have told that the same is the order dated.
Order dated in petition.
With this court. And that's why I was,
I think
that ought to have been a fair submission by a lawyer.
Pata High Court would help that method. Same question for some remaining posts are there. Suppose 62,000 vacancies are there. They publish 57,000.
Not at this case.
Pata High Court, that is why I regarding method prefer
This item number. All same.
for 6
Item number. Petitioner. You are Mr. H.R. Ahmed. For item number 6 and 7, and Mr. Dr.
Yes.
D. Decker, sorry. For 8 and Gupta,
No.
you are for
6, my lord. Item 6.
item 6, Gupta for respondent, and you are for. Give us who are appearing in whose case, for whose respondents and petitioners give us. This was also Mojumdar. Mojumdar can neatly made a submission. লিখিব The learned counsel for the petitioners submit that in view of the determination made by the Honorable Apex Court in case of Union of India versus Prabir Kumar Ghosh and others reported in 2022 12 SCC 250, wherein similar claim as that of the petitioner has been negated. Accordingly, the learned counsel for the parties submits that no cause of action survives for further adjudication in the present petition. In view of the aforesaid submission, the present petition stands closed. Okay.
Very important. Mike,
Okay. Interim orders, if any, stands vacant. ISA, yes. Yes, Mr. Sakya.
The issue of satisfaction. Appointed head of the head court was satisfied.
Who will answer this petition? No affidavit has been filed.
No.
Huh?
So it has been filed. I have to the Hatim Bali also. But they are providing the
Yes, political B department, finance, judicial. Basically, finance will also come at a later point of time, but financial assistance will require Mr. Nayak's assistance, not by way of filing affidavit, but we want your presence. Yes, state. Are you having a copy, Mr. Nayak?
not even he also to make.
See, he is a person, you will have a detailed deliberation. Foreigners Tribunal. Of course, he was a casual employee, but he continued since.
Since my lord 98 he is working, but against sanction post this third part.
Since 2005 he is working, and he post this earmark it is given. He is working, but we will not say that he regularized or, but we want a response from you. He says that slowly, initially contractual, then now some 6,000 or 10,000, something like that. I'm still continuing when it is sanctioned. My post is also shown. There is a post. He is casually work. That is the fact. There is no selection. That is also the fact. Now, a person is continuing. Respond. Let him know what is the employer's stand. Because here affidavit will be necessary, Mr. Secretary. Then we'll get take assistance from Mr. Nayak, whether any kind of relief can be granted within the our power of judicial review. We cannot go beyond that. Let us see that. Okay, that's right, 2007. I think your name is also not shown.
Maybe
Here, okay. The learned counsel representing the Mr. D. Bora, learned counsel representing the respondent number 1, who is will represent judicial, you.
Yes.
1 and 2. Praise that the brief has been misplaced, submits that brief has been misplaced in the office of the senior government advocate. Accordingly, Accordingly, the affidavit would not be filed. Full stop. Affidavit of the aforesaid respondent, the considered opinion of this court is necessary for proper adjudication of the issues raised in the writ. Mr. Saikia, learned counsel for the petitioner, submits that he will furnish extra copies to all the respondents representing extra copies to the respondent extra copies to the learned council representing respondent number 1 and 3, and also to Mr. P. Nayak, learned standing counsel for the finance department during the course of the day. Full stop. During the course of the day. Accordingly, let an affidavit be filed by the respondent number 1 and 3, 1 and 3 within a period of 2 weeks from today. Full stop. A copy of the writ petition also be furnished upon Mr. Nayak, learned standing counsel for the finance department. Full stop. Though at this stage there may not be any role of the finance department, however, if the department wishes, they may also file an affidavit regarding. Full stop. List after 2 weeks. They're gonna file it.
Yes.
Let him know what is what.
Yes.
Let him also know whether you can give him relief or not. Instead of waiting, he's thinking High Court will give him. Let us see.
Very
Item. Yes. Who is your senior?
Father.
What is the matter? Mr. Nayak.
Yes, okay. Then this matter relates to finance department.
There was a specific order recorded by this court
Lot.
on 31/5/2017, where an order was passed on 24/5/2017, where the standing council says that that list is provisional, list there, these that many things were submitted, and said that I have received instruction and will file. And 12 posts of assistant of officers were directed to be kept vacant.
Lot.
And
Right.
we are since 2017, whether those were filled up or not, we do not know. See, there is an interim order against you.
Got to let this matter come on Thursday or Friday.
And a specific stand was there, Ms. Barma submitted that she has obtained detailed instruction and would like to file the affidavit. Interim order pass shall continue. That was the order passed on. You just take note of 31/5/2017. And earlier 24/5/2007. First interim order without notice, then obtain instruction, on instruction 31/5 notice issued, stay continued.
I think that was the last date of it.
No,
Yeah.
thereafter orders, but we do not know. Interim orders were not extended, but there is no modification of the interim.
Lottery will take up this matter on Friday.
Okay.
Friday.
Mr. P. Nayak, learned standing counsel for the finance department, prays that matter may be listed on Friday.
Yes.
9th October. On the aforesaid date, he will obtain necessary instruction under what circumstances affidavit has not been filed since 2007. If possible, you file this affidavit if
Lot.
instructions are there.
That case, I will have the instruction.
That's why I've said not affidavit, instruction. Under what circumstances affidavit has not been filed. Give a copy to him. Or you have,
Lottery, I have already given.
and then you look at this order. Give it up.
the respondent has filed affidavit, we have to proceed.
I am preparing for Mr. Ikeda, standing counsel. We have filed our affidavit of it.
Line for-
What is this matter, Mr. Sharma?
The answer to this is to take money. What are the-
Misinterpretation of
what are the period for the customer but he has hired to advertisement for a post of pure mind. The petitioner has applied one wire one from another set of that. The petitioner could pass that and wire from a second mind. In the Mr. Manual, the post of driver, the driver was suspended and yeah,
okay,
after
Mr. K. Sharma, learned counsel for representing the respondent, petitioner, press for and is granted 10 days time. 10 days time to file a rejoinder affidavit. List according.
Okay.
Yes.
Better part promotion of the petitioner.
Hmm.
That my lord category of person with my lord he a person only the incumbent my lord can take but my lord he was not.
Yes.
Lord, page 16 is the my lord
Who is representing the department? Okay. Okay. No affidavit, no lawyer, let us know. 2017.
Lord he is under the category of blind.
Hmm.
Blind.
Blind.
That is that he is my lord 80 type copy and page 19 is the
It's a promotion method. Tell us the facts first. What
Yes,
when you
my lord.
join, what
Well,
is your
he-
next promotion?
he is
It has
only
become.
the
We'll
incumbent.
come to the blind later on. First thing is that whether you are within the zone of consideration, whether you have acquired the qualification
Yes.
for consideration of the next promotion. Next issue will come.
Yes, my lord.
Whether there is any quota earmark, whether quota is fulfilled or still it is vacant, whether you have a right. These are the cases. If you straight away say I am blind, give me appointment. Can promotion? Can we give? Hmm.
There are 4 vacancies.
No, not your instruction. As per pleaded case. What is your pleaded case?
Uh,
We cannot decide on instruction.
First, I thought way back of 2007.
Uh,
And my lord, I instructed my lord at that point of time, my lord.
no, we are not interested with your instruction. We are interested with what is the
Yes.
case projected by you.
Yes.
Tell us that.
My lord, at that point of time, my lord, kindly come this 28. 28, my lord. Next promotion, my lord, he is my lord serving as a
You take your. So other persons are not before this court.
No, my lord, he is under the category of person.
To understand,
Only
suppose
that
one person is appointed ignoring a quota. There is a quota for physically disabled. Ignoring a quota, he has been appointed. A person. Now, to replace him, we hold that this promotion was meant for this quota, but wrongly been appointed. Mr. Nayak is wrongly appointed. Now, Nayak will have to give away his place to you.
But now the post are, my lord, it is promotion, my lord. My lord, it,
Hmm.
it,
Hmm.
it, not post,
Hmm. Because in all posts you cannot promote a person in all posts, because there must be identification that these posts are meant for. Hmm. 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 Are you aware?
no.
Sure.
It still, but yes, but nothing else.
Because 2014 others were appointed to the post of uh, uh, what do you call it?
Assistant development of
Assistant Development Commission. 13. 2013. Yes, we recall it now. But how far can we wait for the instruction of the department?
Lord, I have the Paravise comment.
To file it.
Because it's a zone of consideration.
Then it was
It-
not within the zone of
It,
consideration.
it was out of 4 posts were there, my lord.
Ah.
4 posts were here, ma'am.
Hmm.
So out of that 4 posts, my lord, 4 into 4 is including him.
Ah.
But 1%.
But so far, in terms of the select list by APSC, his position is at page 2, at 2 serial number on merit. If you have not appointed others, if say, persons from same base is appointed, irrespective of his uh, this disability, his merit position is at 2 in APSC.
My lord, let me get the latest instruction. These instructions way back to 2000. Let me grant us 2 weeks time. For next,
These are persons. What was his position in the gradation list?
73, my lord.
Huh?
74.
74. Therefore, he that is an admitted position.
73. Page 33.
73. Therefore, he wants his appointment to be made in terms of quota, isn't it? In terms of seniority, do not come in the zone of consideration.
Yes.
Now, what is your stand as regards quota?
I thought,
No, not you. Yes, Mr. Kankri, what is your quota?
my lord, as far as quota is concerned, my lord, I have this memorandum,
Hmm.
which is of 2015,
Hmm.
which says that the committee shall consider the matter relating to promotion of PWD
to the grade 2 and grade 3 posts and identify such posts from time to time.
Mm.
Whereas, my lord, those posts have been identified or not? Not that instruction, I think,
This is a grade 2 post.
grade 2 post. And
Uh.
from grade 3, he has got
Uh,
promoted to
grade
grade 2. His main contention is that he was not considered for the grade 2.
No, if you have not identified, you will have to do it. This is a mandate of law. Can you say no, we have not done, so we will not give it?
My
Which
lord,
is
why?
his right is if he has a right, his right is statutorily protected.
My lord, there are 4 posts.
Uh,
So even if 1% is given, 1% of 4.
no, it's not question of four posts. It's a question of how much grade 3 posts are there. What is the quota earmark for them? Whether existing somebody is there. It is not to the specific vacancies. What should be the total strength of grade 2 and grade 3? And if what is the percentage prescribed?
My lord, total 3%, 1% for visually.
Okay, total 3%. Suppose there cannot be both horizontal and vertical. So if 3%, 3%.
That's the matter.
So 3%, these are the 100 posts. 3 are meant for this disabled. Whether already 3 persons are promoted or posts are vacant, and there is no vacancy, you'll have to apply.
But that instruction I'll get whether there are any vacancies or
No, you do it. This is a 2017 matter. We'll
But
put
one
heavy
week
cost
time.
upon you.
1 week time may be given on it then.
See, where instruction is way back 2017.
Not a week's time I'll get.
The Learned Council representing PNRD department submits that he may be granted the last chance to file affidavit by within a 10 last chance to file affidavit within a period of 10 days from today. Prayer is allowed. Release this matter after 10 days. Have it, file it. And be ready with those questions. That question I have put, be ready. We will not grant you time on that day. Then don't say that no, we want instruction.
I pray for a date. Okay, sir.
It will come after 10 days. And Mr. Council, come prepared. Don't make a situation that the lawyer presence is not relevant. Yes, Mr. Das.
In fact, Lordship, there is no surviving cause of action. These 4 petitions can be closed. Lordship, and he has challenged in the first 2 petitions, he has challenged one
Here
notification
it's a series.
series. Sir.
Okay.
And Lordship, the division bench has also upheld that the training is required. In view of the division bench order, Lordship, now this matter has become almost only one person is yet to be retired. All other
Which
persons have
says that
retired.
it has become infected.
But those from were affected from the day they were saving.
You say you have a right for promotion, right for consideration. But he says that has been decided that his qualification is required. So do you want to go to that extent that you have?
That 2017 promotion order he has challenged. And from the 2017 promotion order, Lordship, only one person is yet to retire. All other persons have already retired from service. Now he wants to challenge his this promotion of 1,000. I think he's yet to retire. Only one person.
But I had was their promotion
Hmm.
was
Yes.
acquiring or being promoted
So division bench is upheld.
to division bench said that there was an interim order passed that without qualification when that was after the
Lordship, I have the order.
to have the qualification that was being said. And subsequently those both were picked up and outlined and deadlines were promoted. Lordship, now Lordship, since they were
You are having the qualification.
Yes, they are having the qualification.
But the 1,000 is not having the those who are having the qualifications, they are gone.
In 2020, government has taken action to select the qualifications because they have already completed 25.
Hmm.
That by giving relaxation, they were an order of promotion. Is
Are you continuing in the
They are not
promotional?
considered. Yes, they are promoted. They are considered.
So if we close this petition, any effect on their already granted promotion?
They are already promoted because they are from my they said that no relaxation.
Oh, you have already been promoted. You want that you should not be promoted.
That was the
You are
Lordship,
representing who,
Lordship,
Mr. Das?
Lordship, here, Lordship, FDO, Lordship, they have the qualification of Bachelor of Fishery Science. And we are having
As
the
per-
qualification of BSc Zoology. So they want to bring a classification that Lordship, they are more superior.
Okay, so all these
And-
who are the
And we are
respondents?
from the
let us
same
say?
gradation list. Same gradation list, we are receiving same scale, same salary. But they want
Who is yet to retire?
no Lordship from the first petition,
That's
Lordship, mainly respond number Ram Saran 1000.
Where is the respondent? Who, in which case?
the second one, Lordship 585.
582.
He is continuing.
Respondent number 5.
Reference of five.
Yes, Lordship, Lordship will find at page 18, Lordship, from the gradation list. His date of-
Thousand, Ramchandra Thousand.
Ramchandra 1000, his date of-
Others retired.
others have retired.
Now,
his
the
date of
others also government has given a relaxation,
Relaxation has been given to
all of
uh, including 1000.
including
including 1000.
So you cannot withdraw that relaxation.
promotion order has been issued. That order has been challenged.
Uh.
Our court said that without qualification, no promotion should be.
But prior to that, you have made promotion.
Yeah.
They have.
So they have said somebody retired.
They have retired. And 1000 will retire on 34 2027. And also in the writ petition, they have announced they have not announced the notification.
Okay,
they have-
where do we get that these persons were given relaxation? Then we'll protect 1000 also.
But he may be protected with respect to the date. They were protected, but on that date,
If there is a relaxation, that is a valid exercise. That relaxation is under challenge.
that cannot
Also,
be
before the
because there
interim
was
order
an
was
interim
passed by
order.
this honorable court, also the
No, understand?
promotions were affected.
Affected under an exercise of power of relaxation under
Yes.
a rule.
Yes.
Whether that power of that order relaxing the qualification is under challenge.
Yes, that is under.
So we'll dismiss your petition. Power of relaxation, why should we go?
Because
In a
the
special circumstances,
division bench has already held.
Without
division bench has held that
qualification is required under the orders, and that was upheld. It was said that the department
okay, let us see the division bench. How relaxation decision to relax the rule has been determined?
the basis of
Rule 14. Rule 14.
if the
Just a minute, just a minute. Yes, but view I have expressed that has been decided by division bench. Division bench says we cannot do it. It's an essential qualification. But there is a power of relaxation. It's up to the government. They may do that exercise. They have done it. Why should we interfere? Division bench cover their case.
But they have challenged the date.
You have been promoted already. You have also been promoted. Now you want that your promotion should be effected from the date this person were promoted. That is that liberty you want to re-agitate.
Yes.
Okay, we'll give that. Can you pass a common order in all the cases?
Madhav Chandra College individual repetition lawsuit. In the minus, his selection was there, but was not appointed. So even then lawsuit, we all had training from Amranga 9 months, but the division bench said, hell that lawsuit we are required to have training from Chief Priest, Hyderabad, and lawsuit 1 year training. Since the division bench has said, and lawsuit and Madhav Chandra College he has already retired. Madhav
So,
Chandra
who is for the Madhav Chandra Kolita? Who is representing?
Item number 7.
Who is representing?
I'm
So I will close it. You are for a petitioner,
for the petition.
Mr. Item number
7.
7.
17.
Mr. Das, learned counsel for the
7.
petitioner submits that his read petition has become in process. If you have such submission, read petition stands closed being in process.
And also item number 18 can also be closed in view of the division bench.
Okay.
Same set of
Okay.
petition.
It was 17, 18. 18.
No, 18 not retired.
Full stop. Mr. Das, learned counsel for the petitioner submits that no surviving cause of action to proceed with this read petition. In view, there is no surviving cause of action to proceed with this read petition in view of the determination made by the division bench in the case of in WPC 3546/2021 and other similarly connected cases. Division bench judgment passed on 1/11/2021 in case of WPC 3546/2021. Isn't it one case or many other cases?
There are seven.
7 prisoners per 2020. Accordingly, the repetition stands closed. Okay, 17, 18 gone. Now,
And 16 lawsuit, there are, I represent lawsuit 7 private respondents lawsuit. All of them have retired except House. And that was affected in 2007.
so this now will dictate the order in case of item number 15.
15, I'm not here. 15,
15, there is no private respondent. 15, 16, and 15 and 16. There are 4 matters.
4 matters.
3 टा got, 2 टा got, 15 and 16. 15 and 16 common. Private minister, it is not. In third, Mr. MP Sharma, learned counsel for the petitioner. In WPC 5123/2017 and WPC number 5825/2017. Also heard Mr. Das, learned counsel representing respondent numbers
Lawsuit, I'm just respondent number lawsuit 4, 5, 6, 8, 9, 10, and 11.
4 to 11.
7 is not there. 7 is not.
Okay, 4,
4, 5, 6, 8, 9, 10, and 11.
10 and 11. And Mr. D. Nath for the state respondents. Full stop. Also heard Mr. D. Nath, also Mr. D. Nath is also representing the respondent in WPC. Next, what is that? Item number, where no private respondents are there.
Only 85.
Item number 60. Okay. By filing the writ petitions, the petitioners file the package 15 and 16. Petitioner has assailed an order of appointment, isn't it? Dated 21/8/2017. 21/8/2017. Whereby the private respondents were promoted to the post of Subdivisional Fishery Development Officer, allegedly and purportedly in violation of Assam Fishery Services (Recruitment and Promotion Orders 1989). The further prayer made was to consider the case of the petitioner for promotion to the said post strictly in terms of Schedule 1 at serial number 13 of the said Order 1989. Okay. The primary dispute, the further challenge was the minutes of the meeting of the DPC, minutes of the meeting of the DPC held on 2nd week of August 2017 for considering the case of the private respondents to the post of Subdivisional Fishery Development Officer. Full stop. Full stop. The primary dispute raised in this case is the essential qualification for promotion to the next higher grade, as discussed herein above. As discussed herein. Admittedly, the respondents were not having the required 1-year training of what is called it?
They say from ICAR recognized.
Okay, required training from an ICAR recognized training, which is mandatory for such promotion. The issue regarding the essential qualification were determined by the division bench in WPC 3546/2021 within bracket Hanu, Bora and 10 others versus State of Assam and others. The Honorable Division Bench by its judgment dated 1/11/2021 held that since rule itself makes training mandatory for those incumbents, court cannot pass an order which is contrary to the rules. However, it was further held by the division bench that it is not possible in the given facts of the said case either to declare requirement of mandatory training as unworkable as claimed by the petitioner, or to pass a direction to the state government to consider the case of the petitioners for promotion to the next higher post of Subdivisional Fishery Development Officer, irrespective of their training. However, relying on the however, it was further observed by the division bench that it is it is purely the discretion of the government as the power of relaxation is given to the government under clause 14 of the rules 1989. Accordingly, while declining to interfere with the issues, declining with the declining to allow the prayers made by those writ petitioners, it was left to the wisdom of the government to apply Rule 14 of the Clause 14 of the Orders 89, that is power of relaxation. It is stated, it is an undisputed position that the respondents were promoted by exercising the power of rule of relaxation. Full stop. Rule of relaxation. The other aspect of the matter is that except respondent number 5 in WPC,
5825.
WPC 5825, all the other persons were promoted to the next higher grade after relaxing rule as in the meantime retired. Full stop. Therefore, at this stage, this court is not inclined with the promotion of the respondent number 5, inasmuch as such promotion was granted in exercise of power of the government under clause 14 of the order 1989, which course of action has also been permitted by the learned by the honorable division bench. That being the position, in the considered opinion of this court, no surviving cause of action is there in view of the decision rendered by the division bench in Anu Bora within bracket Supra. At this stage, Mr. MP Sharma submits that the petitioners have also been in the meantime promoted. However, their promotion have not been given effect to from the date the other persons were such grievances may be raised by the petitioner before his their employer. In the event such any order applied, and on such application being filed, the employers have considered their case as per law. And in the event such claim of the petitioner is negated or the petitioner are aggrieved by any of such decisions, they shall always be at liberty to approve this court.
But the promotions were given effective with effect as per seniority in the gradation.
So that's why let them decide why should, that is not a subject matter. Such exercise be carried out within a period of 6 weeks from by furnishing a copy of this order before the respondent number, commissioner, secretary side of it. 3 months. 3 months. Dispose of it. Huh?
8.
SLC minutes. Where is that? Is
party. Thereafter,
the affidavit which has been prepared at the first hearing second as well as the
When have you challenged this order?
2017
Where is the date of order?
court to the order is not supposed to hide the additional evidence regarding children you also explain it
Where is that? Where is your statement? From 2007 to 2008 to 2017.
but page number 9 Lord paragraph 13
Case number
9
paragraph.
paragraph 13 Lord.
Petitioner died on 1811 and he filed application on 312.
Lordship died on Lord 18
Who died?
2004 Lord.
Who died?
Lordship is not father Lord.
What have you written at paragraph 13? Read it. Loud, read it.
The petitioner states that the petitioner but carrying this but corrected but I that I
Where is your additional application?
dated 2011
20,
11
23. Paragraph.
new page number to 94 to dated 4 to but
No, you applied in the year 2015. 2015. Chief Secretary. Will dismiss your petition. Dismiss. Pass the petition stands dismissed. You are Mr.
Yeah,
AR.
I therefore
What is that order? I have passed an order. The third is aware.
my lord is referred to Devabrata Tiwari in that.
Ah,
Devabrata Tiwari.
okay. We'll pass this order. I forgot that.
I can pass a Supreme Court judgment. I will just keep.
No, that is
My lord order.
Oh.
I will take.
because we have summarized the principle for this.
Yes.
20. Yes, madam. Ah. Hmm.
Get the correct
Hmm.
data order in the
Where?
and one
In this case.
Yep.
Where is that order? Same. Dismissed. Same list, 805, that list. In that case, you were also part of that. Hmm. Same list. Same. Same. Dismissed. Whose name should be recorded? R.S. Deuri? Huh? T. Deuri. And Mr. Thor, keep Mr. Keep the name who will appear. Please, even a slip. Give a slip. Dismissed.
My lord, this matter pertains to that Plain Step Corporation. My lord, now is for
None appears for the petitioner on call. None did represent the petitioner when the matter was called on 22/12/2023. According same stands dismissed for not.
I think they have got the money.
If they have not, they will come. Mr. Oh, okay. Give us, give a slip. Just give the item and give a slip. We'll incorporate everything.
That's local.
Yes.
After the order determined 8/1/2024.
Hmm.
So the order between 8/1.
The government has preferred in review petition law, and review petition is allowed.
8/1.
8/1.
Where is that order?
Issue the order.
Let.
আছে নাকি?
Now what to do?
Here the petition is done.
That personnel proof.
No.
Where is the judgment? Give us that. We'll close that in terms of. Where is the disposal order?
But you want 10.
No, it is
Cleaned up. Huh? Cleaned up. Huh? Okay. Hmm. Do you have the judgment?
Dilip Tagdar.
Hmm.
It's been passed by.
We'll have a call on. The present writ petition is filed. Present writ petition is filed. Assailing. Seeking a writ of mandamus. As direction to the respondent authorities to promote the petitioner in the next higher post of section assistant under executive engineer, Albari irrigation division. Full stop. It is the case of the petitioner that the person junior to him has been promoted to the next higher grade, ignoring the case of the petitioner. Full stop. It is undisputed that the petitioner was appointed against a post which was personal to him. Personal to him. Full stop. In view of such undisputed fact, Mr. N. Upadhyay, learned counsel for the respondent, submits that in view of the ratio laid down by the division bench in the case of Dilip Talukdar and others versus State of Assam and others, of masterol and workers / masterol workers regularized to a personnel post, to a post personnel to the respective works as masterol worker, such person shall not be entitled for the next shall not be entitled for promotion to the next higher post of section 86. As there is no dispute that petitioner initially entered into the service as a masterol worker and subsequently his service was regularized to a personnel post, the decision rendered by the division bench, in terms of decision rendered by the division bench, in case of Dilip Talukdar, within bracket Chopra, reported in Dimona 2017 to GLT 1. Comma. The case of the petitioner. No direction can be issued to the respondents to consider the case of the petitioner. In view of the approach, the petition stands dismissed. Parties to be earlier.
Complaint.
Bank employee.
Hmm.
They have patent the position of penalty.
Hmm.
My lord, there is an order in view of the during the pendency of the red petition, United Bank of India has merged with Punjab National,
Hmm.
and there is an order for implementing Punjab National Bank.
Hmm.
I have lost my connection with this petitioner. But still, my lord, I'll make an attempt to.
Okay. Okay.
Otherwise, if your lordship is the involvement is a very small question. Earlier, the writ petitioner came before this honorable court questioning the penalty, and that was interfered with by this.
Now that we understand, but suppose they do not comply with this order, we will be in a bad shape.
Now this man is
The only
85.
thing, my lord, United Bank of India is a defunct body. Now, if your lordship passes an order,
Ah,
that body is not there at all. So, therefore, for his benefit, my lord,
and his benefit. Why don't you
no, he will have to file an application to impeach.
go Thailand?
And now this man is 85. After much difficulty, I could get his phone number from union official.
So, filing an
Is he
application.
alive?
I talked with him yesterday.
They're very
Now,
energetic thing.
my lord, he is now not in.
I will not go into all this. Let me not be in difficulty. We are just adjourning.
My lord,
Mr.
can it be on 6th?
Okay. Mr. S. Chakravarti, learned counsel for the petitioner, submits that a further 10
Oh.
days time,
4 weeks.
4 weeks, 4
Because
weeks time be granted to him to file the necessary application
for implement
or
of
implement of
Punjab National.
Punjab National Bank as party respondent. Prayer is allowed. List according. Sir, as
Can it be
Dr.
on
learned
6th of March?
6th of March, list on 6th of March 2024. Mr. S. Dr. Learned Senior Counsel is present representing Assam, United Bank, erstwhile United Bank of India, which has been merged with the Punjab.
Apply.
Yes. You have gone through? Then argue.
The petitioner was aggrieved by the erroneous judgment on the ground of compassionate
Hmm.
the both of words that it as the section is
Why? Where is your right under compassionate appointment to get a specific post?
lordship
And why are you saying that this is bad?
a post was after the death of
So your brother was holding a substantive post, maybe sectionality. Suppose, assuming for a moment, assume, don't, Mr. Upadhyay, let us assume that. Let us assume that your brother or father, whosoever, was holding a substantive post of sectionality. Now he died in harness. You apply for compassionate act. There is no rule subject to if you can bring into notice saying that a person should be appointed against the same vacancy. Isn't it? And in this case, there was a proposal for regulation only of your brother. It did not culminated in finalization. Okay, since you are seeking a adjournment on the ground of your senior, let us not dismiss we would have allowed, then we would have, okay, who is your senior? B. Kaushik. It is submitted that arguing counsel Mr. B. Kaushik is having some personal difficulty. Accordingly, a prayer for adjournment is made. Prayer is allowed. List. No, will not give anything. Please after quiz.
Right.
Yes, Padgiri.
Take up the item number 27. Last order, madam, 20, 11,
20.
23.
Which method we should take up first?
27, madam.
27. Others are also there.
Not the, this one about the direct file FTDP. Not take the government acquired to the FTDP, but not yet file.
Which order you want to know?
2011, 2011.
2011, 20,
Three.
23.
20.
Here is a order of
Item 27,
item 27. 27. Topon Bormon.
Topon Bormon.
There is a order of 25/9/2023.
After 2011, madam, also 2011.
25/8. Earlier order is 25/8. Then 17/7. There is no other order.
In item number 25, we have filed FTP already. Filed. My lord, FTP Superintendent of Police has filed a FTP response on
What
number.
is this COVDO? COVDO?
Actually VDB.
Huh?
VDB.
VDO.
Circle Officer VDB.
Circle?
Defense organized. Circle organized.
Please.
Circle Organizer VDO. Police Defense Organizer. Circle?
Organized.
Okay.
Circle Organizer. They are helping the police.
Okay, now tell us what to do today.
My lord, sometimes
Affidavit is filed
yes,
in
one
3050.
item number 25, my lord. Affidavit is filed by the superintendent. And the joint secretary, Home and Political Department draft affidavit is ready, my lord. We have to, my lord, file it, my lord. Draft affidavit is ready, my lord. Which time if we can, my lord, in the meantime, we will file it. They are basically they are staying for regular. So, my lord, there is no provision for any casual employees for regular.
Court order.
No, they are not only their grievances of regulation, but they say that you have made appointment by pick and choose without any selection.
Right.
That is their case.
Item number 27. That was that.
If they are continuing, you let them, then it will mean that you have appointed somebody without advertisement. It's a serious allegation.
Yes. Deed and superintendent of
Whosoever, we do not know. Then
The
how
gov-
can you deprive if they are continuing in the unblemished? Let them
The
continue. The
government-
selection is there. Let them participate in the selection.
Yeah.
There may be question of relaxation of it. That is up to the government.
subsequently government has decided to not to continue their untrained homeguard.
That is fine, no problem on this. But the question is, suppose you public employment, Article 16, Article 14 are there. If that is the correct position, that without advertisement, the respondent number 7 and 8 are selected, then you are in difficulty. Yes, Mr. Das. Selected by what means? Oh, authority, we understand. How selection process initiated? Huh? Help. Who participated in the interview? No, the known person who are known to the superintendent. How Article 14 and how Article 16 is adhered? How Article is 14 is adhered? Tell us that.
I have already doing.
No.
I have no preference. But yes,
No, just let you have left a job. That is fine. But we want to know from you for the time being till government, Mr. Sutia tells us, was there any advertisement?
Advertisement made, my lord. The in the Nalbai district.
Okay, file affidavit be ready
Yes,
with the
yes, we will
record.
clear
When
it, my lord. After 2 weeks, my lord.
you at this stage you say that I am not. We have got a better opportunity. We went somewhere else.
I have not.
So when
After 2 weeks.
2009, one is 2023. Okay. Mr. T. Sutia, Learned Counsel for the petitioner, submits that he is ready with the instruction to file affidavit. Accordingly, prays for 2 weeks to file such affidavit. Prayer is allowed. Please, Dr.
Apply.
Yes, petitioner.
Yes. Matter Lordship, regarding process for appointment of for the post of head holder.
Hmm.
The time of filing petition was not knowledge of who is the selected candidate.
Hmm.
After he came to know the name of the certificate.
You file application. Implement allowed.
No, Lordship. Now that's why I should pay for allowed to
No,
file.
who file implement application?
I the petition.
Yes, who representing whom?
Lordship, I am representing respondent number 5, Lordship.
Who is respondent 5?
Principal, Lordship.
Principal.
Principal, actually, Lordship. But we have filed affidavit, Lordship.
Ah.
And regarding the allegation, Lordship.
No. What is your stand? Have you appointed anybody?
Yes, Lord.
Now, who is representing the appointed person?
No, Lordship. Appointed person is not a party, Lordship, in this
You
case.
file an application.
Yes, Lordship.
Okay.
Non-joined
You are
parties,
Mr. Muri. Learned Counsel, Mr.
Deva.
J.U. Ahmed. Learned Counsel for the petitioner submits that recently for the petitioner could learn that a person has already been appointed.
Not appointed, Lord. Selected.
Not appointed.
In time, it's a procedure.
But I think if you selected, you have could come to learn about the selected person.
Lord, it will file at the time application, Lordship.
No, that we understand. Now you are aware.
Yes.
What you call it? Not selected. Submit that the petitioner could obtain the details of the person who has been selected pursuant to the impugned selection process. Accordingly, the Learned Counsel prays that he may be granted 2 weeks' time to file necessary application for implement of the appropriate. Prayer is allowed. Full stop. As there is already an interim order directing not to fill up the post of the grade 4 in the college in question in terms of the advertisement dated 29/10/2018, the Learned Counsel for the college submits that they are having an urgency in this matter. Considering the matter in entirety, list this matter on after 26th of February 2024. If no such application is filed, if no such application for implement is filed, the court may consider for modification of the interim order. Interim order passed earlier shall continue till the next date. You file it.
Okay.
We'll ask them to serve the copy and we'll decide. A college is deprived of a selection.
Connect of this last petition I have directed to put some put it section, some put manual.
We started dictation in this order.
Oh,
When
yes.
it was listed, It was listed on 31/20/24. I think item number 29. Is that it?
That was likely to be completed, but due to absence of under this.
Okay, 8987. 31/2020. When it was listed?
Correct.
When it was listed?
301
24. Huh? Huh? Okay, we'll hear day after tomorrow. Thursday. Please this matter for further some length. Please this matter for further hearing on 8.
10.
10. Consuming. 8. Just keep this.
Yes.
We'll dictate half part is there.
Yes.
We'll get a printout and fun.
Yes.
Yes.
They find the reply. Objection.
They have filed affidavit in opposition. You will have to file a reply.
Yes, sorry. That's all.
The learned counsel for the petitioner prays for and is granted 3 weeks time to file rejoinder affidavit to the affidavit in opposition filed by the respondent number 3. List according.
Otherwise, my lord, this case is covered by my lord or that my lord. Minor. When a father died,
Okay. Since they are
there are two judgments, my lord.
Hmm.
One is from my lord, other is from Honorable Justice Subhan Samar. Two orders.
What is the issue here?
Here, the father had expired.
Hmm.
Was the constable
Oh, minor, that minor. Compassionate upon
Okay, number
2021.
my lord. I'm
You,
just
you be ready with that.
my lord.
Are you aware of that those judgments?
That is better. I wanted to ask.
You have that
These
judgment.
two judgments. One this and
Are you forgot it?
Kotomani.
Yes, Mr. Das.
My lord, things are complete, my lord.
Hmm.
Whether the PRTF
Yes.
Senior is just coming.
Who is your senior?
Mr. SP told me.
Why you need your senior? What is the issue here?
actually they are withholding the payment of it as guilty, my lord.
Hmm.
They are because they are helping of 50 separate may part of the can also the they expired, my lord. As per their notification, actually the petitioner is entitled, but they are compensation, my lord. The extent of 20 lakh. But that has been turned down by the impugn order at page 30, my lord, Annex 7, my lord. Sorry, my lord, Annex 5, page 41.
Affidavit file?
Yes, ma'am. If you they file, we able to file a reply.
Are you proceeding today?
Actually, which I like
No, I don't have any problem.
But
If you are no problem, we can proceed.
I
Okay, I have no problem.
Right.
It is 2020 and we'll decide it.
Well,
When?
in the next
As agreed to by the learned counsel for the parties, please this with the next Tuesday.
date
Next Tuesday.
public
Partition clause is from difficulty. Can you 15th?
15? Thursday? No, already the other.
Okay.
20. Medical problem. It is submitted that Mr. Mohanto, P. Mohanto learned arguing counsel is having some personal difficulty today. And accordingly, a prayer for adjournment is made. Prayer stands allowed. Please this method. 22nd of February. Yes. Hmm? Affidavit filed. Matter stands adjourned on the prayer of the learned council for the peace. List of the peace.
Marty, after if you're here, you want transfer. Transfer. In the
Thanks.
meantime, during penalty of the petition holiday has been transferred. So ultimately,
Nothing survived.
Tenure has been completed, he already been.
Learned counsel for the petitioner submits that nothing survived to be adjudicated in his present writ petition. Full stop. According the writ petition stands close being in process.
My name may be recorded.
Name of C.K. Borua and Mr. M. Islam. M. Islam.
Also,
Yes, Mr. Kolita and Borua.
May I please worship one concerned advocate SS Roy is out of state.
Who?
SS Roy. Kindly adjourn.
When?
Any
It is submitted that Mr. S.S. Roy, learned counsel representing Union of India, is having some personal difficulty to work with this paper. So accordingly, a prayer for adjournment is made. Prayer is allowed. Please this matter.
after two.
19th of February.
No, the 19th February he will not be available.
26th of February.
The intake transfer
Let's say
my name.
when? Not next week. After 2 weeks. Give a date after 2 weeks. No need. It needs to be after 2 weeks. And as Borua for the Union of India.
opposition has been filed, my lord. By the reply.
Not reply. I will see the record and decide. That's all.
Well, it may be admitted before hearing any day you lost it. In the meantime, we will find out if there is our affidavit.
Yeah, let us try the admission because this bench is taking for disposal. So we'll try learned counsel for the petitioner. Press for an is granted 2 weeks time to file the rejoinder affidavit. Mr. S. Dr. Learned Senior Counsel is present representing the respondent bank. Please take order.
Standing counsel Jackie was from Apex Bank. He is out of the
Can take a good start. After 2 weeks. Yeah.
at the door.
Is it the door? Who stopped him from entering to the court? Yes, Saranya, anything survived?
No, my lord, only the national promotion part, my lord. I have retired my intimate during the patent separation.
You are getting pension.
No, man.
What?
Because of this, but professional might have.
Professionally, you definitely get.
Only
Who
thing
is
that,
representing the?
I said it's Bora. I'm coming.
Yes, madam. This matter is pending since 2014.
I have filed FAT.
I supposed to be promoted in 2009. 2009. I have been promoted in 2013. Ignoring my seniority, my junior has been promoted. They respond number 7.
What is their stand?
Their stand is that this is a 10% of the excise per. So I'm working that. So they are saying that yes, I'm doing the different head. The head of account for doing the study head. So other person, respondent 7, he is on a different head, which is controlled by the head of other head. Amalgamated
that is the ground.
I think 2059. I am doing in 2039.
Are you ready for hearing? Because this matter has a rule has already been issued, though it has come in admission. But we do not want to delay much. If
We have nothing to say.
Only thing that they have
except
no
this.
objection, I think. I'm getting that because national problem. Only thing is that whether in a same department, same establishment, if private respondent and me can be differentiated, that is
Okay.
working different.
Okay, we'll take it up this matter on Friday. Yeah. It will come in the top of the list. We'll take it on Friday. Possible, Mr. Saranya? Friday? Okay. We'll just come prepared with this matter. Not Monday? Okay, Monday. Monday, Saranya? Okay. As agreed to by the learned counsel for the party, please this matter on 12. Order. None appears for the petitioner of all. List of all. A week. Item 15. Just a minute. Why order it has been accepted? call Mr. Nayak or Ines Nayak. Sir, please go through this order dated. Are you here till 2? Okay, you just go through order. I am taking it. Go through 24/4/2017 order dated. And subsequent order I have check mark it 22/8/2023 and subsequent order 8/9/2023 because there are still live cause of action. I think so. Contempt may not be, but a person is deprived of pension, clear direction to create supernumerary reports and all. It is a very backward people, they may not know where to alas here. Okay. So you just go through it. If necessary, you can take assistance of finance. Okay. Because if today or no, otherwise it will adjourn it and fix next week or Friday. Okay. Orders matter. We'll just okay. So we'll get back to you. If list is over by then we do not call. Not coming. Might be. Just that's why we want to for our satisfaction.
Yes,
Yeah.
my lord, earlier, Justice Kitchener was chairman. After that, my lord, they have engaged the senior advocate BD that month. And now it needs some time to prepare the case. So, my lord, with time.
2013, let us prepare in the court itself. But you need to prepare. I'm here, will help you. Everything is there. Judgments are there. Okay, let us start.
I'm not having the brief payment.
Okay, I'm having the brief. Let me see. 2013 matter cannot be adjourned like that. May I ask?
With regard to the appointment of the inspector of the deputy director and the CEO. I conducted by the APSC Brigade Service.
Did you participate in the selection?
Yes.
But you were having B.Ed. You were having B.Ed, those they were not having B.Ed.
The leading
Where
case
is the judgment, earlier judgment?
that is the leading case is for Hiranyakumar Nath.
Right.
Hmm?
Was hit by near county Mr. Somehow he has gone through the case of the petitioner wrongly. So he could not appear. In the meantime, not for at least 2 days or 3 weeks, we will engage with him.
Nowadays, we do not wait for seniors. More
Right.
particularly when the matters pertain to a selection of 2011.
To do it. He would do it. Oh.
What is the affidavit, earlier affidavit, on the basis of which you want that there was a determination? So your whole basis is wiped out. What remains?
They said that they
So
No, what is
their whole basis
Was
of the
there.
writ petition is wiped out by a review.
No, let me continue.
Some allegations are
at the
there,
level,
but education
but those
qualifications are not there.
Allegation cannot in three of the court.
Hmm.
When it came before the court said these are all disputed question of the you are leveling something, they are leveling. This is out. This is not the within the jurisdiction of the High Court Order 226. But the main grievance is B.Ed. Now, my
No,
lord,
that is
what
the
has happened?
primary.
No, what has happened? My lord, when the matter came up before this honorable court, we said that there is a review has to be filed for the court. But that was not clarified by some, I don't know, while the matter was disposed of by division bench, I think it was not been properly being able to make understand to the court. That is why some order was passed. Then we file a review, pendency of this case. Then the court reviewed the order. So, meaning thereby, no, today, as on date, B.Ed is not required. So, what grievance they have got? B.Ed is not required.
Paragraph 16 is clear. Paragraph
Review file is a review order.
review order page 16.
Yes.
Therefore, modify, clarify the order dated
Correct.
to the extent that prescription under the rule as on date is requirement of B.Ed for a lower sense, but the same is not a necessary qualification for the higher post of inspector of
And they participated. They participated. It's not that they didn't participate. They participated. They were unsuccessful. And while unsuccessful, they came up and they said, no.
Okay. So what are the irregularities?
My lord, we are paying for time, man. Because
We have rejected your paper.
my lord, because
See, Mr. Pukasta,
in Cosmology,
don't expect at one to rise a court. This is a criminal wastage of judicial time. Whole second half is there. What to decision?
My lord,
How much cost?
so
How
far as-
much cost? Tell us. Any? Are you having any contact with your client?
and one of the
2011 selection. Their age was 42. What is their age now? Tell us.
my lord, so far as item number 1,
Uh.
575
Uh.
there the review has diluted the main that is
Okay.
there.
Okay.
But so far as item number my lord, 51
Tomorrow.
that is
Tomorrow.
day after tomorrow.
Tomorrow. 2030 star on us to
Day
adjourn the
after
case of
tomorrow.
2030. Huh? Okay. Tomorrow. 8 is Friday. Friday. 8.
Right.
And we will not, Mr. will not adjourn on the ground of senior advocate. That is clear. Thursday, 8.
No, it's okay. Please, let it.
No, will not adjourn. These matters 2000.
Tomorrow.
Tomorrow some other important matters.
Well, my argument is, I told you,
Yes.
that is one. Number two is that these are all
Disputed question.
disputed, because somebody is saying that I could not, this certificate on Sunday I joined. They are disputing how these are all disputed
See,
question of fact.
that is, and you will have to satisfy that today selection process. Thursday or Friday?
Friday.
Friday. As agreed to with the learned counsel for the party, please teach me around. Yes, next. Please over. No, will not. No matter. No, let him see, look into it. Okay, we'll come back. No. Okay. 46, 48.
Malad, it is said, Malad, we have been informed, Malad, all the Malad respondents are not in the Malad position. So we have to file Malad affidavit.
Let us see the order.
The order passed by the Honorable Court, you will find at page 18.
18.
18. In Malad contempt case number 705/2015.
705.
Yes, 70. Page 18. Now, operative part Malad you will find at page 24. Basically, Malad page 28. Prasik, Malad.
Yes.
Page 28.
28.
28. Prasik. Since it is the stand of the finance department that unless its corporate department makes the final proposal for clearance of quite all the required particular queries made by the finance department, the final decision cannot be taken independent. Then so that the corporate department to meet all queries which have been raised by the department. Also, submit the final proposal of clearance along all required particular further prepared within 31st of 2015. Since the employees there has been separate about meals it been closed or become fun. Once the requested provide particular
Anything survived? Are you aware anything survived?
Now, my lord, for my instruction, my lord, part paper was made.
PRS was accepted.
That was
If PRS is accepted, matter ends there.
now regarding
See,
that-
what is the direction?
Yes, that is
Direction is VRS to be considered accepted.
Yes.
Two part. One is acceptance of VRS, other part is payment of dues. There is no direction as such on the payment of dues.
yes, that is there.
So we're closing it.
Now, our other friends are also, my lord, with you. Because I have only 2 cases. Other council also
Other
there.
cases, they are not coming, we'll close it. Since you have said that VRS is, because so far we recall, in many cases we have seen there was a scheme for VRS and these were, yes, Mr. Thor, are you aware this Nagaon, not Nagaon sugar mill? VRS was there, then it was accepted. There were grievances. Some were not paid properly. Some was given and writ petitions are pending. That is a different issue. I think you have not. That is a different issue. Hard. Your items are
Our lord, 46 and 48.
46 and 48. Then what is your stand? Same stand. This is a matter of 2015. Payment is not an issue. VRS is given.
Yeah.
Otherwise, by that time, you were around 56, 57 at that point of time.
I was there.
Otherwise, you have retired.
And that sugar mill is no more in existence.
No, that's why there was a general scheme. Their names were not forwarded. It was directed by 31st. If VRS is given, and these people are not having any contact with your clients for last 10 years, isn't it?
Yes.
Hart, Mr. Mondal, learned counsel for the petitioner in who
Invalid.
will represent the contender? Who are the names shown?
I am appearing, my lord, contempt case number 705 of 2015 and my lord, 115/2000.
You are
Okay.
appearing in which case?
2 cases, my lord.
Just a minute. You are appearing in
Contempt case 705/2015 and another case, my lord.
just a minute. You are Mondal in 46. Mondal and
48.
48 on 801. No. 115. Mondal. You are appearing in your name, please. PH. You are appearing on whose behalf? Then A Talukdar DK Sharma. She was here in the morning in some other cases. No, this is different. Okay. Now comes is 45. No, 45 is not related. Huh? No. Who is representing 45? Name is shown and M. Okay. Same judgment on all cases.
Yes, common judge.
This batch of writ petition, 45. This batch of contempt petition are filed assailing assailing willful and deliberate violation of this court's common judgment and or proposed common order dated 13/11/2014 passed in WPC 6092/2010 within brackets 2010 along with other connected restrictions. By the aforesaid order, this court issued the following direction, page 28, paragraph 6. This matter is pending since the year 2015. Mr. Mondal, learned counsel appearing in contempt case number so and so, and Mr. P.H. Kaur, learned counsel appearing in contempt petition number so and so, submits that though VRS has been granted to the petitioner, however, the full benefit under the VRS has not been paid to the petitioner. The direction was specific that name proposal of the name of the petitioner for VRS along with all required particulars was to be forwarded to the Finance Department within 31st of December 2014. As the learned counsel submits that VRS has already been granted. Therefore, in the considered opinion of this court, the order in question has been duly complied. If any grievances still remains regarding non-payment of actual due, the same cannot be determined in the present contempt petition, and the petitioner shall always be at liberty to agitate such grievance in the appropriate forum. Accordingly, the contempt petition stands closed. None appears for the petitioners in contempt petition number 405. So, name of learned counsel first. 49 is up to 48. Disposed of 45, 46, 47, 48. Yes, madam. Anything you have requested?
Yes, Lordship. On last occasion, we have, I produced one copy of the communication, Lordship, where it is stated that the department, Lordship, the government has sent back the file for resubmission, Lordship. This
To
is
whom?
there. To the Bongaigaon, their office at Bongaigaon, Lordship.
Who office at Bongaigaon?
Irrigation department,
Who is Mr.
executive engineer department.
What that? Go through it. We are taking up it on Friday.
Lordship, if I may take your Lordship to page 13 of the contempt petition, Lordship.
Page 13.
Yes, Lordship, because this is little important, Lordship.
Page 13.
Yes, Lordship, 1-3 of the contempt petition. This is a communication from the Accountant General Office, Lordship. And this was written to the government, Lordship, Irrigation Department. Pension case in respect of late Peparuram Roy, ex-Thalasi. Lordship, in this letter it is written with reference to your letter number so and so. On the subject cited above, I am to state that the following defects have been observed in the pension case of so and so. From the pension paper and service book of late Roy, it is seen that he was appointed on 21/1/1956 as worker Thalasi and retired from service on 31/12/1984. His worker service has not been regularized. unless and until service is regularized, the pension, family pension is not admissible to the government servant, as workplace employees are not entitled to any pensionary benefit. Further, it is to be stated here that government servant retired on so and so, and the pension papers has been forwarded by the government to this office only on 5/10/2012. That is after a gap of nearly 28 years from the date of retirement. Reasons for such abnormal delay in forwarding the case of this office may be clarified. In view of the above, I am constrained to return here with the pension case of so and so, with the request to resubmit the same only if the service is made confirmed within his service period with the approval of Finance Department.
Now come to the order. Come to the order. Where is
Yes,
that
Lord.
order?
Page 8, Lord.
Huh? Page?
Page 9 is the cooperative portion, Lordship. This was creation of superannuary post, Lordship.
No.
Mm,
Before
there-
that, there is an order.
This
Huh? Page?
also main petition. Main petition.
Page 6 of the main.
But this is with respect to some other person.
Saraswati Kalita.
But they want similar order. This is not there. Yeah, this is a different.
But there is
Where is your order? You allege contempt? Huh?
me.
Tell us that we cannot consider supernumerary post is not created. Who has barred you from, you have put, even taken proposal?
Exactly, my lord.
Huh?
And my lord will just peruse, since my lord has asked me, I have also done for the file in a different direction, my lord. My lord will just peruse the order dated 24/4/17, my lord.
20 of this
Proceeding, my lord.
24/4.
2017, my lord. This proceeding, my lord.
That I have marked it, no?
My lord is marked it. My lord, the second last para, in the meantime. In the meantime, Finance Department has issued an OM dated such and such. No more regularization, my lord. And here, my lord, it is stated that in the next page that there was a writ appeal.
That's why I flag marked it.
Exactly, my lord.
So that's why I said, where is finance?
They have not, on the last occasion, Lordship, I prayed that they have to implement Finance Department. But it's up to them.
My lord, there is an embargo now of the division bench also, that division bench is upheld in the writ appeal.
And they are
Can
also
we
sitting
get
over
hold
it.
of Mr. Nayak or Gogoi?
Gogoi is today not here, my lord. Nayak, I can always, my lord. Today, Gogoi.
Okay, we are listing this method day after tomorrow.
Okay,
I will
Lordship.
inform him.
List this method day after. No, we understand. We see, we cannot avoid certain things.
Yes, Lordship.
And we cannot adjourn for any time. He
Yes,
is not
Lord.
even he might not be interested.
Yes.
No, my lord.
And since 2010 Lordship,
is
13
still alive,
Lordship,
he-
contempt
he
is
very
they are
much
not
hopeful,
pursuing,
Okay,
Lordship. This
okay.
is also there.
We'll see what is what.
Yes, Lord.
Because to say the truth,
Yes.
the order
Nothing
is
there.
it has
Yes,
not
Lord.
created
Actually, what happened,
any
my lord,
right
at
upon him.
the relevant point of time, these types of orders were
No, we do not know. We are no,
Yes,
we
Lord.
cannot say.
specific orders is may consider.
Yes.
So problem is there. You consider it and say all this.
Yes, Lord.
Matter ends there.
They can pass taking whatever.
Whether and for that this
Now-
method is pending since
Exactly.
2013.
Yeah.
Now, my lord,
And all over the country, people will know that the red mark is blinking at
Yeah.
what I got 2013.
Now, but what happened? But
We cannot avoid, so let list this matter day after tomorrow.
Lordship, showing the
Showing
name of
name of
any.
Mr. P. Nayak.
P. Nayak.
Just inform
I
him.
will
Yes,
inform. I will.
Lordship.
We are keeping this file here for some
Lord.
time. If possible, let him go to it.
Right.
If possible, all of it.
I will tell him to come.
Just make a
Yeah.
request that what is
Yes,
actually,
yes,
what is that finance and who is cooperation. Still you can do it. Still you can do.
They can just pass an order.
Problem is that we don't have the record. To pass any order or to
But-
record.
But from where accountant general said that there is no regulation after 28 years it's been said.
Yes,
That
Lordship.
is there.
It was there. Government has forwarded, Lordship. They forwarded, then thereafter government
have
has taken
rejected.
initiative, Lordship.
So they have rejected.
Yes.
In fact, on the basis of that, contempt can be closed.
Yes.
Well,
But-
government has never rejected me. The accountant general
No,
has
gov-
sent it.
See, government, Mr. Kindly take note of it. We are in a contempt.
Well.
Number one. Number two is government throwing any paper will not be accepted by accountant general. Why accountant general is came?
Yes.
So that anybody will not get anything. They will verify. And they have verified. They
Verified,
said
Lord.
this is not
Yes.
acceptable. So with restraint we have rejected. Meaning there will be a case of pension is rejected on want of regulation.
They could have.
So
challenged it,
exoneration
Lordship.
only
Yes.
remains is there is a judicial order
Yes,
which
Lord.
says that you may consider even by
Lord.
creation of supernumerary post. Now, if they take a decision, that can very well be challenged.
Yes,
That
yes.
why not? Why?
That's
Yes.
why,
What
Lord.
is the rule?
Yes, my lord.
Because there are some notifications.
Yes.
Temporary employees can also be granted pension. All
Yes.
these are there.
Even-
But can we decide all this in
No, no,
contempt
no,
petition?
no.
And
Ultimately, what outcome
can so this is 2013 method.
13
ultimately government
We
has
should
to
not
take
shy away for this old method. We will decide it. day after
Lordship,
tomorrow.
Lord.
Showing name of friend.
On
Yes.
7th, Lord.
Huh.
Keep your.
No part two.
No, no, part two.
Yeah, no.
I was there in-
We will not care. We will not care. We will proceed on.